Good morning, Your Honors. May it please the Court, my name is Donna Aldea, and I represent Jacob Palant. Your Honors, the evidence in this case was legally insufficient to demonstrate that Mr. Palant caused serious physical injury to the complainant in this case. Do
you need medical proof?
No, Your Honor, you do not. However, when there is both medical proof, meaning the medical records, and the witness's testimony, both of which are put into evidence by the prosecution, that in evaluating both legal sufficiency and, more importantly, weight of the evidence, if there are conflicting inferences, this Court must look at both and must determine what the evidence means in relation to both of those two things combined. So in this case, on the element of serious physical injury, this is not at all to detract from the complainant's injuries in this case. She got glass in her eye. I know that the pain was a 10 out of 10 on the scale, on the pain scale, when she got to the hospital. But the difference between serious physical injury, which still results in a very significant felony conviction for this young defendant who has never had any prior criminal history, and serious physical injury, which results in a mandatory 5-year sentence, is significant. And it's legally significant because the legislature did not seek to condition whether one was appropriate or the other based on how horrendous or horrific the acts were that caused it or the degree of risk that they entailed. Rather, instead, the legislature sought to condition it based on the actual injury incurred by the victim. The defendant's acts in this case were horrendous. There's no question. He could have killed people. They could have killed people. Many people. Except, I guess, in some ways, they were lucky. Everybody was lucky that the injuries were not as severe as they could have been. But in this case, where that happened, the prosecutor overcharged it because of the seriousness of the offenses. Serious physical injury is an injury that is on par with death, that is on par with an injury that has a risk to cause death. Protracted serious disfigurement, not a mere minor scar on a leg or an arm, or the loss or protracted impairment of a bodily organ.
So that's what this case comes down to, the second part. So how did they not prove the protracted aspect?
So protracted impairment or loss of a bodily organ, so in this case of the ability to see or vision, requires that there actually be a lasting impact on the person's sight.
How long of a lasting impact?
Well, there has to be an impact that is, according to the case law that we've looked at least the minimum I think that we saw was 41 days for a delinquency proceeding. So at the time of that 41 days, the person still could not see. What we do know is if we look at some of the case law, specifically in People v. Sudol, there was a case where the complainant had suffered actually a shattered orbital socket, which is more severe than the injury in this case, and that shattered orbital socket required surgery. It ultimately healed. It left him with a permanent twitch in his eye, and the court found that that was not serious physical injury under the statute. So every case is a case-by-case assessment, but in this case it's not just the amount of time, it's actually the severity of the injury. If we look at the medical records in this case, it's clear that the complainant, as soon as 2 weeks after the injury, was stating that she had no change in vision, no loss in vision, and was complaining only of intermittent blurriness occasionally. The medical records further show that that intermittent blurriness was happening in both eyes, even though only one eye was actually affected by the glass in the eye. So the doctor diagnoses this as blepharitis. I may be mispronouncing that, but essentially what it is dry eye. And the doctor said she's probably more acutely aware of it in the eye that was injured because of the injury. But nonetheless, at that point, so as soon as 2 weeks after the injury, the complainant was able to see completely. Now, I don't want to avoid the elephant in the room, which is this corneal scar, which is what the prosecutor actually hinges this on. And I have two answers to that, both of which, one is from a legal perspective and one is from a factual perspective. From a legal perspective, we know that the corneal scar did not furnish a basis for serious physical injury as far as the trial court was concerned. And I say this because in response to the defendant's motion for a trial order of dismissal, the trial court recognized that on this record, serious physical injury was a very close call. And the trial court also recognized and specifically stated in denying the motion for a trial order of dismissal and reasoning through it that she said, The inability to use contact lenses, the scar, I don't believe amounts to serious physical injury. But based on the totality of the circumstances, she let it go forward to the jury. That would be on sufficiency review, not on weight of the evidence, which is this court's power to weigh conflicting inferences. But she said that the reason she did that is the fact that the witness testified that she had blurry vision sometimes and was unable to drive at night, which would be considered a protracted impairment of a bodily function or organ for somebody of that age. Obviously, if you're 90 and you're not able to drive at night, I think that's a natural state. But given the victim's age, she said that the inability to drive at night was the injury. Well, here, what we know, actually, we know it based on the records, but we also know it, more importantly, based on the district attorney's concession before this court in their brief, that in fact, the victim was able to drive at night. She did not have a problem driving at night, in spite of the trial prosecutors' misrepresentations of that fact to both the court and to the jury at trial. We know that she was actually driving at night without any glasses or corrective vision wear after this incident, and in fact, that was the basis of the 330 motion that was subsequently submitted to the court. So, the corneal scar. Sorry, I digressed a little bit.
Counsel, I just want to understand.
Yes.
The evidence about her ability or inability to drive at night was established at trial. The trial record shows she could drive at night, or the subsequent post-trial surveillance shows it. What's your position?
So what happened is, at trial, the testimony was actually very unclear on the point, because, just to give the court a little bit of background, part of the problem here was that nowhere in this witness's grand jury testimony, where she delineated the nature of her injuries, did she testify that she could not see, had permanent blurry vision, or could not drive. She never noted that there was a problem with her night vision, her ability to drive. It was not contained in the People's Bill of Particulars. It was not contained in any of the discovery material they gave to the defense. In fact, the medical evidence or the medical records that were given to the defense in discovery and were subsequently put into evidence at trial showed the opposite. They clearly showed that there was no vision loss and no change of vision as of 2 weeks after the incident at all, which meant that there wouldn't have been any difficulty seeing at night. So this witness gets on the stand, and suddenly, surprise, the prosecutor says, well, what about your ability to see at night? Can you see at night? And the witness says, no. She actually says, no, I cannot see at night. So the prosecutor asks her about driving, and the witness's testimony is a little bit unclear. The witness says, well, I cannot see, and then she subsequently says, I wear glasses for that. It's unclear whether the glasses were pre-existing, in other words, she had glasses that she used at night before this injury, or whether they were related to the injury, and that was never clarified. In the 330 motion subsequent to that testimony, what happened is, well, I actually backtrack a little. In the trial order of dismissal, this became an issue because the trial judge founded the denial of the trial order of dismissal on this witness's surprise trial testimony the defense attorney knew nothing about, that she couldn't see or drive at night. So now it became an issue. Following the trial order of dismissal, the defendant hired a private investigator who went out, who surveyed the victim, and who in fact found that she was regularly driving at night.
And the trial judge felt that you could have obtained that information before, and you're arguing you didn't get it because you didn't know that was an issue.
Correct, Your Honor. And actually, there is case law on that. The problem here is that you can't say that the defense attorney, the trial attorney, could have found this before with the exercise of due diligence when it was never disclosed. If this had been the theme of the grand jury testimony, if there was even a notation about it, arguably in the discovery or medical records, then sure, it would have been incumbent upon the defense attorney the trial attorney to go and investigate this prior to trial. But where that wasn't permitted, there was simply no way for that to happen.
What was the theme in the grand jury? Obviously, they introduced evidence regarding the serious physical injury, and what was the testimony, and was that part of the trial? Was there cross regarding that?
So the testimony in the grand jury never mentioned the inability to see at night, never mentioned the inability to drive, did mention intermittent blurriness and the corneal scar, and did mention the pain that she felt obviously at the time when she first got the glass in her eye. The pain is actually not relevant to serious physical injury, it's relevant to physical injury. The corneal scar, which I was about to get to, I'm actually going to address now. So here's why the corneal scar is legally insufficient. The first legal reason that I had alluded to is that actually actually, on this appeal, we don't challenge the portions of the record that the trial judge ruled in favor of the defense. So the trial judge on the motion for a trial order of dismissal already stated that the corneal scar was not serious physical injury. So for that reason, legally, this is not an issue. And the people under People v. LaFontaine can't come back to this court and argue alternatively that we should challenge that determination. But beyond that, on a factual level, here's the problem. When we talk about serious physical injury, what the case law means is you look out and you can't see, or you look out into your general field of vision and everything's blurry. That is a protracted impairment. And whether that lasts for 41 days or 7 months or 1 year or is forever, as the prosecutor stated in this case at trial to the jury and to the judge, regardless of how that happens, it's an impairment that is serious, right? In this case, what the witness testified to at trial with the corneal scar is that if, she said, you can't see the scar when you look at my eye, but I can see it. I can see it if I look peripherally in my field of vision and I focus on that scar, I can see a small blurry line that is the corneal scar. And here is the distinction. If you try to look for the scar and you notice it when you try to look for it, that's not an impairment of your ability to see your field of vision in front of you. That's a conscious decision to focus on a scar, to focus on an imperfection. It would be tantamount to saying, when I cross my eyes and try to look at my nose, I see my nose and then my vision goes blurry. But I don't have to choose to focus on my nose. I can choose to focus on my field of vision, which is clear. So this victim's corneal scar was not a serious physical injury. It was a physical injury, but not a serious physical injury because it did not impact her ability to clearly see her field of vision when she was not focusing on it. So, for all of those reasons, under legal sufficiency analysis, the 2 assault counts should be reduced. This is not tantamount to the defendant getting away with something or with getting away with having committed a heinous crime that he's not being punished for. As I said, this is a very serious felony conviction for a young man with no prior criminal record who even the sentencing court noted, the sentencing court stressed the fact that she understood that his culpability was limited, that he had been led someplace dark by a person who was much more culpable than he, by his co-defendant, who had a long and lengthy criminal record. And she said that she was nonetheless constrained to give him this minimum sentence of 5 years incarceration because it was the mandatory minimum. So he doesn't get away with anything. He has a felony conviction as a result of this, but it's a felony conviction that gives the court the ability to sentence him properly for the crimes that he actually committed, which the legislature has stated are based on the type of injury actually sustained.
Was there evidence that there was a pre-existing condition that you refer? What is the evidence? Because there is follow-up, and I'm sure the people will address this, that there was testimony regarding follow-up appointments, which suggests that she was still having a problem. However, if she had a pre-existing condition, then you might have an issue with respect to why she was visiting the doctor and follow-up. So what was the evidence as you see it?
Yes, so she did testify that she did have vision problems prior to this. She did testify that she did have to wear glasses for driving prior to this, and she did in fact have glasses prior to this. So that was in the testimony. We don't have all of her medical records except for what's in evidence as Exhibit 30, which this court has as well, that detail to the events after the incident. So what we know is, based on her testimony, she did have vision issues before. Now, her follow-ups actually amounted ultimately, the medical records in Exhibit 30 show that contrary to the prosecutor's representations at trial, she actually was allowed to wear contact lenses again 3 to 4 weeks after the injury. The prosecutor at trial told the jury and told the judge that she would never be able to wear contacts again. This was forever. This was permanent because of a risk of infection. That was just not true. It wasn't corroborated by the medical records. We also know that ultimately she was visiting the doctor for every 6 months, I think it went to, which is not that uncommon actually for purposes of checking your vision. It's either annually or biannually, depending on your vision conditions. We do know that there was no reported change in vision based on these medical records that take us through. So the injury happened on December 26th, and this takes us through mid-March. And in that time, on each of those visits, it said that there was no vision loss, no reported changes of vision, no infection that had been detected, nothing. So all of that, according to these records, indicate that there was no protracted loss. Additionally, even if...
And yet she testified that she had pain and blurry vision, and it got worse after the attack. She said she couldn't wear contacts due to risk of infection, which you discussed, and it was difficult to see at night.
Correct.
So that's what the jury had. It had the medical records on the one side and her testimony on the other. And while the medical records, she suffered 10 out of 10 pain, she said it was 11 out of 10. The jury went that way with her rather than the medical records.
Well, I think part of the problem is that the way that the testimony came out, as I said, because this was something that hadn't been brought out before and that was surprise testimony at trial, there really was very little examination of her on these issues. There was no opportunity for meaningful cross on this because this was surprise testimony that just came out. And I do think that if Your Honor looks at the record, at the testimony that she gave, the testimony is actually very unclear as to the questions of what impact this was. The pain that she felt, the occasional blurriness that she felt, well, it was explained, and she didn't contest, it was explained by dry eye, and it was in both eyes. So that would tend to say, well, it's not related to the injury, there's a lack of causality. If you have testimony like she gave that she had difficulty seeing at night, the question that is pressing, right, that really kind of weighs upon us now is, was that injury a pre-existing injury, or was that caused by the incident in this case? And we don't know the answer to that. We do know that when the prosecutor told both the judge and the jury, this is forever, this is permanent, we know that's not true. We know that's not true because 7 months after the victim gave this testimony at trial, she was driving at night on a regular basis without wearing glasses. So we know that that's not true. And so based on that, and actually to further illustrate the lack of clarity on this testimony, I'm going to actually rely directly on the prosecutor's brief before this court. Because in his brief before this court, directly contrary to the prosecution's position below...
Page 17.
Yes, Your Honor. He says very clearly that there was never any doubt in anyone's mind at this trial, there was never any doubt that she could see at night and that she was able to drive at night. And that is simply contrary to everything that the prosecutor said below. So if the people took an inconsistent position below, and if in fact the truth is, as the people now acknowledge, that she was able to see at night, that she was able to drive at night, then the prosecutor, as an officer of the court at trial, or subsequent to that at the 330 hearing, at the 330 motion, or whenever they learned this fact, had an obligation to go to the trial court to correct the record and to say, Your Honor, I improperly suggested to you and the jury that this was the nature of the victim's injuries, that these injuries were forever, and I was wrong in that. So I want to correct the record and make sure the verdict is not upon a misapprehension. So, Judge Austin, when Your Honor says that the jury chose to make this determination between the medical records and her testimony, actually that's not entirely accurate. The people chose to make this determination based on an affirmative misrepresentation, as we know now, by the people at trial, by the prosecutor, that she was unable to see, that she was unable to drive, that she had blurry vision that was constant, and that, quote, this was permanent, this was forever, this would never get better, all of which was false. So we can't let the verdict rest upon what we now know and what the people have conceded is simply a falsity. Now, with respect to this claim, Your Honor, I would ask that the court actually reverse this conviction in the interest of justice under weight of the evidence review, because I think that's actually the correct way to do it, viewing the record on balance. It can be done under legal sufficiency review. I think weight of the evidence is more correct. In the event that this court does not do that, certainly the court should send it back to the trial judge for a hearing on the 330-30 motion, because the court denied that motion without a hearing, citing to the very same case, People versus Hirschhorn, which was a decision that was actually based on legal sufficiency analysis. And legal sufficiency analysis, in other words, saying under People versus Hirschhorn that this is enough, this close question is enough to submit to a jury is not the correct standard on review on a 330 motion, when the standard actually has to do with whether there was a potential to prejudice or a potential for a different verdict if the jury had heard the evidence. So at the very least, it should be sent back for that hearing, although we would ask for reversal on weight. Additionally, Your Honor, and I know that I've used a lot of time, so I'm going to be relatively quick on this point. The second point, or rather the final point in our brief, actually has to do with the court's charge here. And the court's charge in this case was, with all due respect to the trial judge, frankly a mess. This was a charge where multiple...
Corrected it, didn't she?
Excuse me, Your Honor?
She corrected it, both before and after the jury note.
Actually...
And nobody objected to what she did.
Your Honor, I agree with Your Honor entirely that nobody objected, so this claim is unpreserved, and I concede that. I would ask that this court should review this claim in the interest of justice because of the magnitude and nature of the errors that were made, which were not corrected. The most egregious, there are several errors that were made here. First, we had an indictment that was really charged or drafted very poorly. Multiple counts of the indictment charged identical language without specifying a victim, without specifying a time, without anything to distinguish them. So if you look at the indictment itself, the two reckless endangerment counts were absolutely identical. No victim charged, no time charged to specify or distinguish one from the other. If you look at the criminal mischief counts, there were 3 criminal mischief counts. Every single one of those counts was identically worded, no victim specified, no distinguishing time, no distinguishing factors. That is a multiplicitous indictment, and as charged to the jury, it continued to be multiplicitous because the trial court actually recognized, to her credit, the trial judge said, this indictment is a mess. But this is what you charged, and so this is what I'm charging. This is how I'm charging the jury. So it's not just how the indictment was drafted, but how it was charged, that the counts were multiplicitous, the same conduct was charged in multiple counts, and so we have no way of knowing whether the jury convicted the defendant for 3 counts of criminal mischief, for example, or 2 counts of reckless endangerment based on identical conduct. And that's a violation of double jeopardy. The other problem, which is also pervasive in this case, and which the trial judge did not correct, the trial judge mischarged the jury repeatedly, over 6 times, so half a dozen times, repeatedly, in virtually every offense on the elements of acting in concert. And specifically, her error was this. Under Penal Law 20, when we talk about acting in concert, what is required is that the defendants both engage or act together. They can act independently and just assist each other with the actus reus of the offense. But each defendant must independently have his own mens rea in order to constitute acting in concert. What the trial judge charged 6 times, both with respect to the assaults and with respect to the criminal mischief and with respect to the reckless endangerment, she repeatedly charged that the mens rea could also be shared. And one of the mens rea elements was, one of them was recklessly, one of them, for some of those charges, was depraved indifference. So she actually charged that if you find that one defendant or both defendants, either acting alone or acting together, shared this mens rea, then sometimes she said you must convict, sometimes she said you can convict. That's just wrong. The mens rea element cannot be shared. Each defendant has to have that independently. So while it is true that the court did give a general acting in concert charge, which stated the standard correctly, when she then goes on and advises the jury half a dozen times to a charge that's contrary to that, we can't rely on it. And the reason that it's not harmless in this case, and this is my last point, I promise that I'll sit down, the reason that it's not harmless in this case is because there was real evidence at this trial that this defendant may not, in fact, have been able to form or have shared in his co-defendant's mental state. And I say that because although the evidence was overwhelmingly clear that all of these boys were on the bridge together and may have assisted each other in throwing the bricks over the overpass, what was not clear, and what the trial judge even noted that she wasn't entirely convinced of, was that the mental state was shared. Denton was the co-defendant who had the lengthy criminal record and violent crime. Denton was the co-defendant who suggested that they all throw bricks over the overpass. Denton was the co-defendant who was walking along the edge of the overpass and acting crazy when the other boys were telling him to come back. And Denton was the co-defendant who was sober. and the only one of these 4 boys who had not smoked incredible quantities of marijuana just prior to this incident and during this incident. So the jury, if properly charged, was very likely to find that even though Jacob Palant was on that bridge and may have acted in concert with Denton as to the actus reus, he did not share or was not able to form or did not have the requisite mens rea, particularly of depravity, that would have been required to sustain those convictions.
Can you just
Argument
address-
made on summation?
Excuse me, Your Honor?
Is that the argument on summation?
No, Your Honor. Your Honor, the argument, that was not the argument that was made on summation. The argument that was made on summation actually had to do with whether or not he was even throwing the bricks, because there were some problems with respect to that as well. 2 of the witnesses who testified were actually accomplices as a matter of law. They were cooperating with the police. They initially said that Jacob was not throwing stones, then they changed their story. And witnesses described kids throwing bricks, but never described Jacob. They described people wearing hoodies when he was not the one wearing a hoodie. So there were some issues with respect to that, and that's what the defense attorney focused on summation. But with respect to analyzing the impact of the charge, this court has to look at the facts, look at the charge, recognize there was a mistake. I think even the prosecutor will agree with me that the charge was a mess.
What about the fact that she was always giving clarifying in the charge that each defendant was to be considered separately?
Well, saying that they're each to be considered separately is great, but then when you tell the jury that you must convict if you find that one or both of these defendants shared in this mens rea, then that just undoes that. So we would literally be left guessing as to which of the jurors, if any, correctly understood the charge and how they understood it. They understood that you consider them separately. They understood that you can convict both or acquit both or convict one and acquit the other. There's no question that they understood that. But they didn't understand the proper standard. In other words, my fear and what I believe happened here is I believe that there's a very real likelihood that they could have said, Jacob Palant helped Denton bring the bricks to this overpass. He helped him throw the bricks over this overpass. And even though he didn't share in the wanton depravity that Denton had in his mind, even though he wasn't that guy, it doesn't matter, because they acted in concert. They acted together. So because the prosecution proved the depravity and the recklessness as to Denton, proved the culpable mental state, then Jacob could be found guilty under an acting in concert theory. That's what the charge allowed for, and it allowed for it 6 times. So the errors of multiplicity, the errors of duplicity, would allow, as the prosecutor stated, and I agree, that this court, in fact, would mandate that this court just strike the counts that are multiplicitous and leave one standing. But the errors with respect to the charge on the acting in concert and the shared mens rea requires a reversal and retrial on those convictions.
Thank you.
Thank you, Your Honor.
For the people, Assistant District Attorney John B. Latella. Good morning, all. There were a number of things stated with respect to serious physical injury, so I'll begin there. The consistent pattern of blurry vision, pain, and sensitivity to light in this victim's left eye, which lasted for 17 months after defendant's actions the day after Christmas in 2015, establishes serious physical injury, and this court and the courts throughout New York State have held precisely this in numerous cases citing in the brief. We've mentioned Hirschhorn already, but certainly Justin G., Timothy S., and Meneses, all cited in our brief, establish clear law that these impairments of this victim's eye are serious physical injury under this statute.
Does it affect the weight of evidence that her testimony was inconsistent with the medical records?
I don't believe necessarily, as I argue within the brief, that her testimony is inconsistent with those medical records. In the first instance, we have the blepharitis reference, which is contained in only a single report and which, as noted, states that it exacerbates the symptom. The blepharitis is exacerbated through the trauma that she's experienced.
Is blepharitis, you're saying blepharitis is a serious injury?
I'm saying that, no, I'm saying that if we believe that these medical records establish that she has blepharitis, and there's no way to establish that since it's only contained within a single point, the fact of the matter is that it is the actions of the defendant that exacerbate that blepharitis and produce the protracted impairment that satisfies the
protracted dry eyes.
That's correct. That would be a serious physical injury, yes.
But isn't that something a doctor would really have to testify about?
That's correct.
Because you're asking us to look at it from the perspective of a doctor saying she had the dry eye and now you have this injury and this exacerbated. There's no testimony regarding that from a doctor, right?
I'm sorry, but there is no testimony from a doctor. But the medical records certainly state that it's exacerbated. And if we're going to argue about the medical records versus the victim's testimony, it's fair to note that the medical records don't in fact negate anything that this victim has testified to. But beyond
But she was
that,
able to drive at night when she testified that she could not drive at night.
Again, here I'll push back both upon appellant's brief and some of the questions. The record is clear that she can drive at night. That's her testimony on page 1313. I could read it, but I think that your honors are probably familiar with the import of her testimony. But it's clear that she can drive at night. Her ability to do so is diminished. It might render it not a great idea for her to do that, given that she now has an increased sensitivity to light, which requires a new prescription for her left eye, but she can drive at night. And there was no serious question at trial as to that point.
Wasn't that part of the basis for the judge finding? I thought it was part of the basis for the judge finding a serious physical injury that she couldn't drive at night, that based on her testimony. Wasn't that part of the judge's analysis?
I think that the judge's analysis was confused, and I'm not sure that the judge conclusively states in the trial order of dismissal that, nope, it's clear she can't drive at night, especially since it's an unexplored issue at trial because the testimony is clear that all that she's suffered from is a diminished capacity for it, given her sensitivity to light, which makes sense in a larger context, that you'd have glare from street lights and headlights, et cetera.
I apologize. She didn't testify that she couldn't drive at night? I thought she did.
At trial, she testified that she could drive at night, that she had a diminished ability to do so, and that diminished ability necessitated an additional specific prescription for the sensitivity to light in her eye.
So let's segue that discussion into the charge that the judge gave, or the charges at various points.
In which sense, Your Honor?
Well, there were so many
Multiplicity,
senses that
duplicity.
seem to be highlighted here. The confusing nature, the first charge she gave, the correction that she did, then the fact that we have charges without dates, times, and victims, the whole thing.
As Your Honor pointed out, certainly the judge corrected any misstatements. She said, scratch that, check that, ignore that, and delivered the appropriate standards.
What
at all
about the
points
mens rea?
of the charge.
What
But-
about the
I'm
mens
sorry.
rea? The mens rea.
All right. The mens rea becomes interesting in this case in the following ways. It becomes interesting as to the criminal mischief counts, and it becomes interesting as to the assault counts. That's fundamentally where I believe appellant's argument rests with respect to mens rea. There's a few problems. There are a few issues that we should, I believe, explore. The language personally or by acting in concert with one another did so recklessly. That's with respect to the criminal mischief accounts. That doesn't alleviate the people of their burden on the criminal mischief counts of proving the defendant's mental state. This is so because the jury is properly instructed as to acting in concert, and the acting in concert charge requires that the defendant evince his own culpable mental state. Moreover, that charge on acting in concert, coupled with the court's repeated instruction to consider each defendant separately, plainly ensures that the jury is going to proceed by finding that defendant Palant, and only defendant Palant with respect to their verdict on defendant Palant, evinced the necessary culpable mental states. But moreover, because the acting in concert charge addresses the proper legal standards, it is irrelevant how the jury proceeds, whether they are finding him guilty under an acting in concert theory or an individual theory. And the reason for that is quite clear. It's because the acting in concert charge says the defendant's own mental state. So under any theory, this jury has to conclude that defendant Palant evinced his own mental state.
Shouldn't we be able to look at a verdict and know what the jury did, which choice it made in terms of the conviction?
I'm sorry?
Shouldn't we be able to look at a jury's verdict and say they did it on acting in concert, they did it on individual culpability? We don't know that from this verdict.
But that's irrelevant to the inquiry, as I mentioned, because under either theory, they arrive at the same result. They're legally required to arrive at the same result. And this court has repeatedly...
What about the charge where she says, and/or, Andrew Denton and/or Jacob Palant?
The and/or language refers, I believe, to the reckless endangerment counts.
Right.
That's correct. Two responses. In the first instance, the and/or is a rhetorical device. And it's clear that
Was that
after having...
explained to the jurors? Was that explained to the jurors?
Whether she's using a rhetorical device, I think given how the judge has repeatedly charged the jurors to consider each defendant separately, would render any juror readily able to assume that that's a rhetorical device. But moreover, the and/or on the page to which Your Honor is referring only referred to part of the elements of reckless endangerment. It referred to the recklessly engaged in conduct element. With respect to the depravity element, the judge specifically said, the defendant. So it's clear that the judge is making sure that the jurors are considering these elements in these counts separately as to each defendant, the and/or formulation notwithstanding.
What about the fact that the criminal mischief and the reckless endangerment charges in the indictment do not set forth date, time, place, and victim?
Well, simply put, Your Honor, they don't have to, as the trial testimony was quite clear that there were 3 cars damaged, hence 3 counts of criminal mischief, and that there were 2 separate instances of reckless endangerment. And in fact, defendant appellant's complaint on appeal with respect to reckless endangerment is entirely waived, because it was the people who said, you know, Judge, we'd like you to say afternoon and evening or some formulation thereof for these 2 reckless endangerment counts. The defendant goes, no, I don't want that. I want the jury as confused as possible. Now, it turns out this jury isn't confused, but that's certainly defense counsel's attempt at trial. And the jury comes out with a great note. They say there were 2 distinct differences as to both reckless endangerment charges. And the people go, you know, there's no harm in clarifying that the distinct differences effectively go to afternoon and evening. And the judge goes, well, I'll tell them to consider the whole day. The jury goes, and they come back with guilty verdicts on both reckless endangerment counts without sending a further note. So the jury understood the very basic trial testimony.
What if one of the verdicts would have been not guilty and the other guilty? How would you have been able to know which crime they were convicting, which incident they were convicting the defendant of?
It would have to... I don't know that you could necessarily differentiate it, but based on their note...
Doesn't that reveal an infirmity in the way it was presented to the jury? I mean, if you can't, you have a guilty and a non-guilty, and you can't figure out which incident a person was convicted of, isn't that a problem, counsel? I mean, it sounds like it is, but maybe I'm off mark here.
It would be a hypothetical problem, but the conduct is very clear as to both time frames. I don't think the jury could possibly have rendered that verdict at that point, and you might have been able to move for repugnancy at that point based on the fact that there's, I mean, they're brick throwing in the afternoon, they're brick throwing in the evening.
They arguably could have found that the other individual that didn't come back in the afternoon
They could have done that,
involved
that's
in
right.
the first incident.
Right, and they could have split they could have, because they were proceeding, and Your Honor's quite correct on this point, because they were proceeding on each defendant having their own mens reas, done precisely what appellant has suggested and said, no, defendant here, appellant, was a puppet on the strings of Denton. We're going to acquit on the morning, or we're going to acquit on the evening, or render some kind of compromise verdict at that point. So in that respect, you're correct that the mens rea and the requirement to consider each defendant separately could have produced those verdicts.
Anything else, counsel?
Are there any further questions from the panel with respect to any issues brought forward? Seeing no further, I can rely on the remainder of the brief. The judgment should be affirmed, and I thank you.
Your Honors, I want to invoke, there are 4 misstatements of fact, narrowly, that I want to rebut, and I'll do it quickly. The first one is the prosecutor stated that the medical records show that the dry eye was exacerbated by the injuries. So I'd like to direct your attention to the medical records at page, they're not numbered, but if you number Exhibit 30 sequentially, it's page 48. And on that,
What's the exhibit, counsel? I apologize.
it's exhibit number 30, and there are no pages